Good afternoon. Thank you. Please be seated. Thank you for your courtesy. This is the time set for oral argument in our case, captioned Madison Square versus Chicago Title. Our cause number 1CA CV140115. We have reviewed the briefs and arguments and issues. We're prepared, we hope, for your oral argument, and I'm sure we'll have some questions for you. Each side is allotted 20 minutes. Counsel for appellant, if you wish to reserve some time for rebuttal, you need to watch the clock and tell us, and we'll try to honor that. And if you would say your name before you argue, we'd appreciate that for the recording. And having said that, the counsel for appellant, you may proceed, please.
Thank you, Your Honors. Good afternoon, Your Honors. My name is Jamie Thompson, and I'm counsel for Chicago Title Insurance Company. This is a case where the trial court judge flip-flopped multiple times before entering the ruling that we're here about today. She first denied summary judgment for both parties, then granted summary judgment for my client, Chicago Title, then reversed that decision, and based on the exact same facts and legal arguments, she granted summary judgment in favor of Madison Square.
Just for the record, when she reversed, I know that the party changed. Did the facts or allegations change?
No, they did not, Your Honor. And in fact, at the oral argument, the parties agreed to that. The contract terms were exactly the same. There was just an error in naming the correct Chicago Title entity, but it had absolutely no bearing on the facts of the case.
Okay, yes. I don't understand. I guess it doesn't matter for the appeal, but I don't understand how the name of the party affects summary judgment.
It doesn't, Your Honor. It was just a mistake that neither party picked up, and that was ultimately used to reverse the summary judgment. I'm not sure why, but there was no bearing, and in the oral argument, the parties agree that it does not bear on liability.
Just to close this issue out, there was no argument made that the change of the parties altered the legal circumstances so that it would have reversed the decision on summary judgment?
There was an argument raised that the correct entity didn't have a right to conduct business in Arizona and therefore couldn't have brought litigation. We were defendants anyway, so that didn't apply. And ultimately, they agreed that we were entitled to conduct business and basically withdrew that argument. But that was the only argument that was ever raised as to why summary judgment should be reconsidered based on the parties.
And that's not what the court decided on?
The court said based on that argument, she needed to reconsider and reversed. But then ultimately, everybody agreed there was no issue.
All right, thank you.
So after the court made her third or so summary judgment determination, granting summary judgment in favor of Madison Square, we filed this appeal.
Yeah, we're most interested in who won the last time around.
Madison Square won the last time around, Your Honors, but I believe that decision was based on some crucial errors, and we'll get to those in just a moment. I think first it's important to discuss some of the relevant documents and the parties' roles under those documents, because I believe in their brief, Madison Square attributes some rights and duties to it that it plainly doesn't have under the documents. The first of those set of documents is the Centex lease, the addendum to that lease, and the tenant improvement rider. This is the document where that term approved tenant improvements comes from that you'll see throughout the documents. It's a set of documents that sets forth procedures for Centex to do improvements to the leased property, and the landlord is the person who has the right to approve those procedures. Now, there's no dispute. At the time the improvements in question here were done, CCATM was the landlord. Madison Square was no longer the landlord, and they had assigned all of their rights under that lease and the tenant improvement rider to CCATM.
But still,
Go ahead.
it's still Madison's money that's at issue.
Madison's money is the money in the escrow account.
So that your argument is that CCATM, that's the right name?
Yes, it is.
CCATM, could approve the improvements, but to get reimbursed, they would have to send everything to Madison, and Madison would have to say, go ahead and disperse the funds.
Well, I would agree to some extent. Send everything, I think, is a little bit misleading. There are clear documents that are required to be submitted under the tenant improvement rider. Those are construction plans, architecture drawings, and those are documents.
And invoices, I assume.
Invoices come after the tenant improvements are approved. First, they say, these are bids, here's what we're going to do. Then CCATM approves those. They become approved tenant improvements. Then Centex does the work. Then Centex submits invoices and checks for reimbursement, and that's what gets forwarded on to the escrow. So it's two separate procedures done at different points in time and between different parties. CCATM and Centex are the only parties involved getting to the point where they're approved tenant improvements. Then after the work is done, the escrow and Madison Square become involved, and that's when invoices are sent for approval.
Invoices and a request for disbursement.
Correct.
And they get sent to,
They get sent to Madison Square. Madison Square's only ability is to review the invoices and proof that the obligations were incurred, and then object or consent to the disbursement.
do nothing.
Or do nothing and deem its consent. So Madison, throughout the briefs, argues that it was entitled to review the tenant improvement approval procedures, or that it didn't get to do that. But the documents are very clear. Madison assigned any rights under the lease and the tenant improvement rider to CCATM. So those decisions were CCATM's alone. The other set of agreements I think is important is the purchase agreement and joint escrow instructions, and the third amendment thereto. Those documents rather lengthy and detail the terms of the sale between Madison Square and CCATM. I'll say CCATM. Canberra was actually the party, but they immediately transferred their interest to CCATM. So now, again, under those documents, Madison specifically assigned to CCATM all of its rights under the lease. And those documents, the joint escrow instructions portion of those documents were escrow instructions relevant to the sale escrow. That's separate and distinct from the construction disbursement escrow, which is the 3-page escrow agreement that's at issue here. And that is really the key document that we're here about today, that escrow agreement. That was an escrow agreement entered after the sale transaction had closed, when the construction disbursement account was set up. That was a document that superseded all prior agreements with respect to disbursements from escrow. So that's the only document that governs the disbursement at question here today. Madison Square, at multiple times in its brief, relies on prior terms in the purchase and sale agreement that were expressly superseded by the escrow agreement and which are not applicable.
There's only one document governing the $225,000?
There's a 3-page escrow agreement that was entered by the parties that governs the disbursement.
And it's paragraph 2 of that document that seems to be the key.
That is correct.
The one that says buyer shall be entitled to disbursements from,
Exactly. Paragraph 2, disbursements from the account. That's the paragraph here that controls
buyer
disbursements.
shall deliver copies of invoices, contracts, or other evidence that buyer has incurred its obligations to seller and escrow holder, together with a request that the escrow holder disperse to buyer the amount of the obligation incurred by buyer from the appropriate account. And then it talks about the consent.
Correct. Now, that is the key language, and it's our position that that language is very clear and only requires proof that the obligation has been incurred, like a check, an invoice, something saying, hey, they've done the work, requested the money, we need to pay them. That doesn't include the construction plans and the bids required to get approved tenant improvement status.
So it illustrates the incurring of the debt, but not necessarily the propriety of the amount of the debt.
Well, you have to do receipts and invoices, so the amount of the debt and the incurring of the debt, but the other steps required to get approved tenant improvement procedure are not required to be submitted for the disbursement.
Thank you.
The escrow agreement also doesn't require both parties' signatures. That's something that Madison argues that came from a prior agreement, and that was before an escrow was thought of. They were going to just have a joint account where two parties had to sign. That clearly isn't what happened. The escrow agreement makes no reference whatsoever of any signatures, let alone joint signatures.
Does the escrow agreement require that copies of these documents be sent by CCATM to Madison and Chicago Title?
They do. The limited documents set forth in the escrow agreement, yes, it does say that they should be sent to, by CCATM to both Madison and Chicago Title.
Does that not suggest that the escrow agent, Chicago Title, as a fiduciary, has a duty to make sure that the copy was the original, or at least a copy was sent to Madison?
Well, Chicago Title did do that. It's our position, Your Honor, by sending those documents to Madison itself. Now, we would disagree with the trial court's interpretation that the only way Chicago Title could meet its duties was to call up CCATM and say, hey, did you send these? Rather, Chicago Title sent them themselves. Now, there's evidence in the record that Robert Knight testified that he gathered the necessary documents and sent them to Chicago Title in the form of a draw request. There's also evidence in the record showing Kevin Flores emailed Madison Square's partner, Gerald Bostic, a PDF called draw request.
Do the escrow instructions require that 4 different offices of Madison be given notice?
They do not. Now, the escrow agreement does incorporate the notice provisions of the purchase and sale agreement, but only with respect to notices required to be given under the escrow agreement. Here, Chicago Title had no duty to give any notice under the escrow agreement, so those provisions don't apply.
So CCATM may have had an obligation to send notice to 4 offices.
Correct. But Chicago Title did not. Now, Chicago Title's only duty was to make sure that Madison Square had received the documents sufficient to trigger the deemed consent period. Chicago Title met that burden when it sent the documents to Madison Square itself. Now, under Arizona partnership statutes, that was sufficient to give Madison notice of the request and sufficient to trigger the deemed consent period. And I think
Do you think we need to assess whether your assertion is correct under Arizona partnership statutes and law?
Well, I think to determine the notice issue, the notice provisions don't apply, so Arizona law would, and I think those are the relevant provisions to look at.
So I want to make sure I understood that. Not the partnership agreement, the partnership law, but this duty on, were you saying that Chicago Title had a duty to ensure that Madison had received all the necessary documents supporting the draw request?
I think in order for the deemed consent period to have been triggered, Chicago Title must have known that Madison received the documents. And it's our position that Chicago Title did know that by sending the documents to Madison itself via email that's in the record.
If they had not been sent I think they may have been labeled at some point as a courtesy copy. If they had not been sent, then the draw shouldn't have been paid out.
I would argue that there could be some interpretation that because CCATM sent the request, it's fair to assume that they had also sent it to Madison. However, we don't need to get there because the draw request was sent by Chicago Title to Madison.
So since in that there's not another methodology, if you will, for Chicago Title to have knowledge of Madison's receipt of the documents, you believe that the understood action was that Chicago Title would forward on what they received? Is that a fair statement?
I believe that all that Chicago Title was required to do was reasonably believe that Madison had received the documents, and that Chicago Title did that by sending them the documents.
Did they elect then to do that, or was that something that was maybe an unstated provision or a misunderstood provision or an oral agreement?
I think they elected to do that to confirm that Madison had received them. I think you could argue that they could have called CCATM instead, but the route that they chose to confirm that Madison had received them was equally effective to start the deemed consent period.
Thank you.
I'd like to move quickly to the other key issue as I see it, which is the trial court's error in finding no evidence to refute the damages issue. We've cited to no less than 3 places in the record where Robert Knight testified that the tenant improvement approval procedures had been followed, that he believed that they had been met, and that he believed that the disbursement was appropriate pursuant to the tenant improvement rider. The judge ignored all of that testimony and reached a decision based on alleged admissions by CCATM, which were not even admissions. There was a notice of no objection.
Do we need to reach that issue if we agree with you on the that Chicago Title's sending on the reimbursement form to Mr. Bostic was sufficient to trigger the time period to run, the 10-day time period to run?
No, Your Honor. If you agree with us and you rule in favor that Chicago Title did not breach the escrow agreement, then the damages issue would become moot. But just to reiterate, there is substantial evidence in the record on the damages issue. And I would argue that Madison Square failed to present any admissible evidence to controvert that evidence. The things they rely on are, one, a argument and a motion that there was no evidence, which we know is untrue, and two, the notice of no opposition filed by CCATM. That is not an admission even against CCATM, and certainly not a binding admission against Chicago Title. I'll reserve the rest of my time unless there's more questions.
Thank you, counsel.
Thank you very much.
May it please the court, my name is Julie Linneman, and I'm here on behalf of Appali Madison Square Development Partnership of Arizona. This case can be disposed of based on 3 concessions by Chicago Title, the most important of which the court has already addressed and again was raised by Chicago Title here at oral argument this afternoon. Chicago Title effectively concedes that if the last sentence of paragraph 2 of the escrow agreement requires that the request for disbursement come from the buyer, the Chicago Title wrongfully dispersed the funds from the escrow account, and therefore the judgment in favor of Madison Square must be affirmed. Chicago Title attempts to excise this one sentence from paragraph 2. Well, as the court well knows, its longstanding rules of construction require that any provision be read as a whole. And moreover, in addition to being read as a whole, that the provisions of the text be interpreted as compatible and not contradictory. When you look at the provision as a whole in paragraph 2, it's clear that the request for disbursement must have come from the buyer. Well, if it didn't come from the buyer, Chicago Title wrongfully dispersed those funds.
Does it, go ahead.
Go ahead. You go ahead. Let me go first last time.
Does it matter if it comes from the buyer and stops briefly at Chicago Title and then goes to Madison? It still kind of comes from the buyer.
It absolutely matters, Your Honor, because the parties negotiated this particular procedure for notifying our client of any request for disbursement, and it wasn't followed. Most importantly, aside from coming from the wrong party, which wouldn't trigger knowledge on our client's part that it was a proper request, it also didn't go, there were other problems with it aside from that one piece, but focusing on this buyer issue because that is the most important part. When our client is expecting something to come from the buyer with respect to any request for disbursement, and it doesn't come from the buyer, it's a breach.
Well, is it a material breach, though? It isn't the issue whether or not you're given notice and the opportunity to object to the disbursement?
It's, in our view, it's undisputed that we weren't given notice, first and foremost, because it didn't come from the buyer. But you could go even further, which we really don't believe the court has to even get to, by saying we couldn't possibly have realized that this was, this wouldn't, in the best of circumstances, this wouldn't be considered proper notice or even an immaterial breach of that provision because it didn't come from the proper party. It came via a method that we did not agree to. And in fact, it came via a method to only one person who was supposed to be copied on the notice, not even receive the original notice. There are so many problems here that one action sort of triggers and snowballs.
So when you got the emails, you thought maybe Chicago Title was trying to play a trick on you?
No, our client didn't. The reason, I think I need to back up to answer this question. The reason that our client insisted on such stringent notice provisions was because the nature of their business requires that they're not always in the office, they're not always in the country. There are a million reasons why one person may not even be aware that it has received an email of some sort or of one that requires a certain short time to respond. And therefore, the notice provision was a critical piece of this whole transaction to ensure that our client could preserve its right to not only respond, but possibly object if necessary.
It seems to me quite logical that a business might want it to be sent to several places in order to help make sure that it was given attention in a timely fashion. Would you help me here, please? I think I understood Ms. Thompson to say that the requirement of sending it to 4 different places within Madison was found in a different document and not in the 3-page escrow.
Your Honor, that is what Chicago Title stated, but that's not how the agreement actually reads and not the proper procedure here. The provision was initially drafted for the purchase and sale agreement. The purchase and sale agreement's notice provision is in Section 18 of that agreement. Turning to the escrow agreement, Section 6 of the escrow agreement expressly incorporates by reference that notices under that agreement must comport with the notices in Section 18 of the purchase and sale agreement. And I'm going to raise an issue because I think it's important for the court to know that that provision, the Section 18 provision that outlines the stringent notice requirement, specifically says notices and all communications between the parties. So even if something isn't specifically stated as a notice, all communications between the parties should have followed this notice procedure.
Between the parties, meaning Madison Square and CCATM.
Your Honor, by incorporating that provision into the escrow agreement, of which the escrow agent, Chicago Title, was a party, Chicago Title was bound by that as well, although it really doesn't matter because it was the buyer who initially failed to follow that notice provision.
Granted.
And as a result, Chicago Title breached its contractual and fiduciary duties.
And how did Chicago Title breach its contractual duties? If Chicago Title, I don't see anywhere in the agreement on paragraph 2 that says Chicago Title has to give notice to buyer about a request for disbursement. Is that a fair statement?
Yes, Your Honor. Chicago Title was required to confirm that the buyer followed its obligations prior to dispersing any money from the escrow account.
And where is that in paragraph 2?
Well, Your Honor, it's Chicago Title's obligation as the escrow agent to review the documents, read what the parties' obligations are prior to any disbursement, and confirm that those obligations have been met prior to disbursement.
And what's the authority for that? What's the authority that they have, that the Chicago Title had a duty? It gets the request.
Right.
It gets a request.
Right.
And let's assume it doesn't do anything.
Sure.
It just sits there, and then 10 days later or 12
Sure.
days later, assuming that CCATM had separately sent it to the buyer.
Sure.
What's your best authority that Chicago Title had some kind of obligation to make sure that CCATM had separately sent that request to Madison Square?
First and foremost, the parties' agreements that Chicago Title would perform under the agreements as in the acknowledgement under the purchase and sale agreement, and then again in the escrow agreement. And second, Arizona law, which says that the escrow agent is required to review the agreements and confirm that the terms have been met prior to doing its job by dispersing the money.
In other words, does Chicago Title have a duty, let's say, to say, not only confirm that it was sent, but review all the invoices and make sure that the person sending the invoices and the request had authority to do so, and that the person that at Chicago Title at Madison Square had authority to authorize or not to authorize the disbursement? Does it have a duty to do all of that?
Chicago Title has an obligation at a minimum to confirm that the parties have met their obligations in this instance by providing proper notice of a request for disbursement and by ensuring that whatever the buyer thought was proper documentation to support a disbursement has been provided to Madison Square for Madison Square's consideration.
And what's your best case on that?
Our best case on that, Your Honor, is is in our brief, and it is, I believe, Birkins, and there are a few others that we cited too as well that support that position.
So Chicago Title basically has kind of a super overseer lawyer position to interpret all the provisions of the various agreements and how they interact, and not just operate in regard to their responsibilities. Wait a minute, but ensure that each of the parties is acting in regard to their responsibilities the way Chicago Title deems appropriate under the agreements.
I would vary from that a little, Your Honor, and say that Chicago Title had an obligation to understand the terms of the agreements, and if it didn't, or if it had a question, it had an obligation to look into it, meaning, at a minimum, again, discussing it with the parties and confirming that the parties that the terms had been met according to the parties prior to actually making the disbursement. And if I may, Your Honor, looking here, Chicago Title couldn't possibly, without doing a little more due diligence, know if the 10-day deemed consent period, which it says triggered its decision to disperse the funds, had even started, let alone expired. Because there's nothing in the record and nothing in this courtesy email that it talks about that demonstrated that Madison Square had received notice or anything from the buyer about this request for disbursement, which was the very first and fundamental term that had to have been met for any disbursement to take place.
But there's also no provision in the agreements to advise Chicago Title that the disbursement process had even been initiated. Correct?
Forgive me, Your Honor, I'm going to need you to repeat that question.
Where in the agreement does it indicate how Chicago Title is to be made aware that CCATM has communicated
Sure.
to Madison the disbursement request?
Because under the terms of the agreement, specifically this paragraph 2 that we've been discussing today, the buyer, CCATM, had an obligation to send the request to both Madison and Chicago Title.
And by Chicago Title receiving it, then they would assume that Madison had received it as well.
Your Honor, that's where we argue that Chicago Title, prior to dispersing any funds, had an obligation to confirm if it had not received some proof that Madison Square had received the request and that the request was properly noticed to them. The Chicago Title had an obligation to first check with Madison Square and confirm that it had received this request.
Does it carry out that obligation by sending it to Mr. Bostic?
No.
Why not?
For several reasons, but first and foremost because the provision, paragraph 2, requires that the request come from the buyer. So Chicago Title forwarding it to Madison Square is not enough.
It never could be enough.
It never could be enough.
What if Chicago Title called Mr. Bostic and said, did you get it? Yes. Have you talked about it within your company? Yes. Are you going to do anything? No, we're not going to do anything. Would that be enough?
No,
It has to
not
come,
under the terms of the agreement.
it has to come directly from the buyer.
Correct.
And yet the terms of the agreement mandate that CCATM perform in that fashion, but they do not task Chicago Title in a similar fashion.
No, but Chicago Title, as the escrow agent, has an obligation to confirm that CCATM has done what it's supposed to do prior to receiving Madison Square's money.
But the law in the state of Arizona is pretty clear, isn't it, that the duties of the escrow company are as stated and stipulated in the escrow agreement?
And by entering into this escrow agreement, Chicago Title, even under Arizona law, but in addition, by acknowledging the purchase and sale agreement, becoming a party to the escrow agreement, Chicago Title agreed and acknowledged that it was going to perform by the terms of the agreement, which include that it will ensure that the buyer has properly provided this request for disbursement and that Madison Square has received it.
Let me give you a hypothetical. Let's assume that Chicago Title, got this request, and complied with all the requirements of notice, sent it by certified mail, hand-delivered it, whatever was required, to all 4 people, wouldn't at least that be sufficient to trigger the time because the escrow agent is an agent of the buyer of CCATM?
I think that my initial answer is no. It's not, because it still doesn't comply with the terms of the agreement, which requires that it come from the buyer.
But if the buyer sends it to its agent and its agent sends it to and complies with all the other requirements, why does it have to come directly from the buyer if it's through the buyer's agent?
Because the buyer...
The principal's bound by what the agent does, as long as the agent has authority. And Chicago Title is also the agent of, I guess, the agent of both. So why doesn't, if it comes through, assuming it got sent to everybody, I'm not asking you to say, I'm buying in, at least for the purpose of the argument, I'm buying into your argument that to comply, it had to go to all these people in the form required by the sale agreement. So why isn't it that if they had sent it on, Chicago Title had sent it on in the appropriate fashion to everybody with all the supplement, all the documents that paragraph 2 required, that wouldn't be sufficient? They had actual notice. Everybody had actual notice. It came from an agent of the buyer.
And you're saying that it also contained, in theory, it also contained the documents that it was everything was correct.
Everything was meant. It just got there because it didn't go directly from CCATM to the 4 people that buyer. It went to the agent, and the agent sent it on to all 4 in the appropriate fashion. Would that be sufficient?
No, because it still doesn't inform our client that it is what it's supposed to be.
Okay. So
what does that mean, though? I'm sorry.
Because
what does
it
that
doesn't
mean? It's not what it's supposed to be.
Well, because if our client is looking for something from CCATM, something comes from Chicago Title, it doesn't immediately look like proper request. It could be a bill for services. It could be anything.
Or if your client had read it within the 10 days.
But he
didn't. And if I understand it properly, what the cover email said was, here is the request for reimbursement attached to PDF file. And I'm assuming that would include the request that it received, that CCATM made, saying here's whether it included all the documents or not. There's a request made from CCATM that's sent to Chicago Title. Chicago Title says, here's the request. So you open it up, you look at it, you say, oh, what's attached? You look at it, and there's the attachment from Chicago Title. So if Mr. Bostic had read it, assuming that it was, assuming that was sufficient, at least that would be saying it's from the buyer. I know who it's from. I can see who it's from.
I think, using the most strict version, no, it's not enough. And I, would also just add, now I think you corrected this in the hypothetical that you just gave me, but there are no documents that were produced in this case that we've never seen what was in that draw 1 PDF to the extent that the court is assuming that it was exactly as we received it. And curiously, the 2 parties who were a part of the original email, CCATM and Chicago Title, who both were parties to this case, never produced whatever was allegedly in that attachment.
Presumably, you could have contested the necessary. Did you contest down below that the necessary documents were not attached to the
Of course.
email? And and so you said there was nothing attached. The necessary documents weren't attached.
We don't know what was attached.
What do you mean you don't know what was attached?
We've never seen what was purportedly in this draw 1 PDF.
Your client received it. Your client received, right? Mr. Bostic received the email from Chicago Title that says attached or is the request, the disbursement request in the PDF file. He did get that. Right?
The only way that I can answer this, Your Honor, is as you know, if you hit reply, for example, to an email that the original has an attachment,
Right.
oftentimes you'll see what looks like a record of an attachment to a previous email, but the attachment is not there.
But if you
That's-
hit forward, it's attached.
I dispute that that's not always true either, and I also,
It all depends on the
System.
default settings.
Okay.
it's not always there.
So-
And
Did you have affirmative evidence in the trial that said there was nothing attached?
we had negative evidence that no one ever produced what was purportedly attached, and I'd like to, and which is okay. The negative evidence can be probative, but I'd like to also add that it doesn't even really matter because we never get to whether the documents were attached or whether the improvements were appropriate because
And you're out of time, but let me see if I can summarize what I understand your position is on the notice. It's that the notice had to come directly from CCATM, sent to 4 different people by a certain method, attaching all of these other documents that are required under paragraph 2. And that it doesn't matter whether Chicago Title sent it on or not. And that Chicago Title's duty is not that it had to send it. Chicago's title duty was to ensure that or confirm make the appropriate takes necessary steps to confirm that CCATM had sent the request with all the supporting documents to the 4 people at Madison Square by directly, by the necessary means, and it had been received.
that's correct. And because that didn't happen, Chicago Title breached its contractual and fiduciary duties, and the judgment should be affirmed.
Your strongest case on that is Burkitt's.
And the additional cases that we cited in our brief. And for that reason, the judgment should be affirmed, and we should receive an award of our attorney's fees and costs on appeal. Thank you, Your Honor.
Thank you very much. We have a little bit of time for rebuttal.
At least 5 minutes and 34 seconds.
Thank you, Your Honors. Excuse me. The meat of this appeal is what duties Chicago Title had under this written escrow agreement. Now, I think the problem with Madison Square's argument is it's trying to impute some duties that just aren't there in the writing. They're not there.
One of the things that has puzzled me about this issue of duty, and we didn't get to it when you were up before, but now we can, I hope. Our cases say that the escrow agent is a fiduciary and stands in a position of fiduciary trust to the other parties and so on. And then our cases say, well, but the escrow agent must strictly comply with the escrow instructions. I can see your argument, which is, among other things, that Chicago Title strictly complied with the escrow instructions. But what about the fiduciary duty? Did it not have a duty to do something more here than just the bare minimum that was done?
Well, let me answer your question in 2 parts. One, that fiduciary duty extends to 2 parties, which is why it's so important that they strictly comply with the terms of the escrow agreement to avoid a situation where they're favoring one party over the other, which is possibly what could have happened here if Chicago Title went beyond what was required of it by the written escrow agreement and said, hey, well, you need to send me X, Y, and Z to prove you did what you were supposed to do. Chicago Title could have delayed payment, risked a lawsuit by CCATM saying, hey, that wasn't your duty under the escrow agreement. Why did you make us do all those extra steps? That is why it's so important that an escrow officer strictly comply with the escrow agreement and the terms that are written. Now, here, you guys are right that there's no clear written agreement as what Chicago Title was supposed to do, if anything, to confirm that notices were sent. Under that scenario, Chicago Title acted in a reasonable fashion by determining, okay, I need to trigger the deemed consent period. I'm going to forward this on to my contact at Madison Square, make sure he has everything he needs so that deemed consent can start.
Okay, but having undertaken that, shouldn't Chicago Title then have confirmed that it was received and was being appropriately considered?
I think by emailing it, he reasonably could have believed it was received. There's evidence in the record that email was typically used between Gerald Bostic and Chicago Title as a method of communicating relating to this escrow. I do not think a follow-up phone call was necessary. We dispute factually that Gerald Bostic did not receive and read it immediately. The only evidence on that is his self-serving testimony. We're clear he got the email because he responds to it, months later, but he responds to it. So it was in his inbox. Additional testimony would be needed to prove that he just didn't even open it at that time.
Do you have anything to add to the discussion right before you came up about what's in the record as to whether there are any attachments that are in the record?
Yes, Your Honor. I would dispute.
I haven't been able to see them.
I would dispute their argument that they disputed that issue on the trial court. There was no direct statement of facts, that this email included the invoices or statement of facts saying it didn't. That issue just wasn't specifically addressed. However, if you look at the record, there's deposition testimony of Robert Knight saying he included all of those documents in the draw request to Chicago Title, and then the email forwarding the draw request to Gerald Bostic has that attachment, draw1.pdf. Now, the logical inference from that evidence, which is the only evidence in the record on the issue, is that it included the supporting documentation that was included with the draw request.
Doesn't it also? I'm sorry.
But the attachment is not in the record.
The attachment the printout of the attachment is not in the record, but you can look at the email and see attachments, draw1.pdf, where it was clearly sent.
And then there's no affirmative evidence that says, hey, there was nothing attached, the necessary documents weren't attached.
Correct. They don't refute that it was sent.
What about, I'm sorry, were you?
I was just going to finish that line up by saying, doesn't the email say something about enclosed, please find?
Yes, it says enclosed for your review, please find the draw request as well as the attached escrow agreement. So Kevin Flores is saying, here's the stuff we got, review it. If you have an objection, the deemed consent period has started, please object.
For summary judgment purposes, taking reasonable, even though looking at all the evidence in light most favorable to you, basically, for purposes of whether if we reverse and said there's a fact issue, or if we reversed and said you're entitled to summary judgment, depends on how we want to look at it. But we take all reasonable inferences, and the reasonable inference is that Knight says, I attached everything I needed to attach. Chicago Title sends an email on saying, here's the request, there's a PDF attachment, enclosed, please find.
Correct.
And there's no evidence countering that there's nothing, the necessary documents weren't attached.
That is correct, Your Honor. That is the only evidence, and I think it requires a finding on that fact in our favor.
Perkins?
Your Honor, I don't think Perkins says what they believe it does. I mean, Perkins talks about the escrow agreement controlling and fiduciary duties. It doesn't require Chicago Title to do things that plainly aren't contemplated by the parties and aren't provided for under the escrow agreement.
Oh, and doesn't it address largely the issue where ambiguity exists?
Correct, and if there is an ambiguity here, which is at best what I think what Madison Square can argue, that there was some ambiguity as to what a reasonable escrow officer should have done or what an escrow officer would have done, and that would require a fact finder to determine that issue.
But there's also a difference between an ambiguity in a contract and just the absence of a provision in a contract, isn't there?
Correct, Your Honor, and I'm saying at best there's an ambiguity. I think by the express terms of the contract, you can read it as not requiring Chicago Title to send notices. That was a duty that CCATM breached, and CCATM should be here today, not Chicago Title.
In essence, if Chicago Title hadn't done anything, just waited the 10 days and dispersed, it wouldn't have breached technically you're saying it wouldn't have breached the escrow instructions.
Technically, it would not have breached the escrow instructions.
Sending it on, so therefore by sending it on, how could they have breached the instructions?
Correct, and by sending it on, they definitely confirmed that they had received it and that the deemed consent period had started.
I think we're finished.
Great, thank you, Your Honors.
Thank you both very much. We will take the matter under advisement and issue our decision in due course. We appreciate Ms. Linneman and Ms. Thompson's arguments, and we will be in a brief recess so the next group can come up. Thank you.